Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. If you're working in immigration law, you already know that there's never enough time in the day. That's why the team at e-Immigration has been sharing a ton of helpful resources to make your life a little easier. Head over to their resource center and you'll find on-demand webinars, practical tips for building your 2026 budget, and insights to help your team work smarter, not harder. Whether you're planning for growth or just trying to create a calmer workflow, there's something there for you. Check out eimmigration.com/IRP and start 2026 with more clarity and less stress. Or of course, click on the special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy New Year! I'm back, everybody. I was in Japan. Can you believe it? With a 16-month-old. Who thought that was a good idea? You had a great time. But man, kids are nuts. None of you told me. Great country. And great job, Liz. I've included Liz's email in the show notes if you'd like to email her yourself, telling her how great she was the last 2 weeks. There were no cases last week, but there are certainly cases this week. Also this week, before getting to the cases, the Ninth Circuit certified a question to the California Supreme Court. Are controlled substance analogs means or elements of a controlled substance offense in California? Obviously a huge deal, so stay tuned with what the California Supreme Court says. Looks like the Ninth Circuit's going to enter the whole divisibility, cocaine, methamphetamine, isomer, analog argument very soon. Also, a few weeks ago, the Second Circuit vacated an illegal re-entry conviction for a former lawful permanent resident who had been twice or thrice convicted of illegal re-entry, based on a finding that the original removal order from 2000 was invalid because his drug conviction was not in fact an aggravated felony. Why not? Because of United States v. Mintner, episode 176. That's United States v. Ramirez-Rodriguez, and it seems like quite the important decision for, a motion to reopen in the Second Circuit. Check it out. And now I will not continue further without saying Renee Nicole Good's name. Rest in peace. You don't need me all to weigh in on the context of her killing, though I'm sure many of you know where I stand, but I will stop to just note how gross and scary it is to see the White House and Senate-confirmed leaders literally lie about what a video shows of a death. Have we as a country fallen so far in such a short time that it will work with a large portion of the country? I fear the answer to that question, I really do. And her name was Renee Nicole Good. She had a future and people who loved her. And now she's dead. And for what? What important policy goal or principle of governance required her sacrifice? Though right there, I must stop. All of us, myself included, immediately get sucked into the bigger questions when these things happen. But if we lose sight of who the human being is, who is now dead, we do an injustice to that person. I won't do it anymore with Renee Nicole Good. Here are the cases. Here's how lawyers fight back, safe behind our computers and in our suits. Listen if it pleases you. Our first case is United States v. Ferguson, published by the 8th Circuit on January 6, 2026. This case is about cocaine isomers. Spoiler alert, they make a state conviction overbroad in the 8th Circuit without need to satisfy the realistic probability test. Mr. Ferguson was convicted in federal court of, you guessed it, felon in possession of a firearm. Surely a U.S. citizen, he will be getting more time on his sentence if his previous conviction for delivery of a controlled substance in violation of Arkansas Code Annotated Section 5-64-401A1AI is what the Armed Career Criminal Act calls a serious drug offense. For our purposes here in immigration, that requires comparing the Federal Controlled Substance Act drug schedule to the controlled substance schedule that Arkansas criminalizes delivery of. Restated, the same analysis we use in immigration. Or as the Eighth Circuit explains, without mentioning the realistic probability test, quote, if Mr. Ferguson's prior Arkansas conviction for delivering cocaine was under a provision that criminalizes substances not listed in Section 102 of the CSA, that prior conviction cannot qualify as a predicate offense for the ACCA enhancement, end quote. It appears, although not stated, that the Eighth Circuit believes the Arkansas drug schedule divisible such that it can look to Mr. Ferguson's conviction to see that he did deliver cocaine. So this case is only about cocaine. As we all know, the federal government criminalizes, quote, cocaine, its salts, optical and geometric isomers, and salts of isomers, end quote. So specifying only two isomers, optical and geometric. Arkansas, in contrast, as with so many states, maybe all of them, I don't know, criminalizes all cocaine isomers. That is, different chemical cocaine compositions, if I'm not mistaken, which I never am on my own podcast, that I also serve as executive editor of. And Mr. Ferguson's right. After all, explains the Eighth Circuit, in its 22 decision, United States v. Owens, the Eighth Circuit held that, quote, a drug statute that criminalizes even one additional isomer does not qualify as a serious drug offense, end quote. So pretty on point. DOJ tried its best with three arguments which were rejected by the court. First, explains the Eighth Circuit, Arkansas does indeed criminalize more isomers than simply geometric and optical. While the analysis is a bit complicated and specific to Arkansas law, the important point is that, quote, a state law that criminalizes the isomers of a controlled substance and does not contain any limiting language criminalizes all isomers of that substance, end quote. Emphasis by the court. That's what Arkansas does by criminalizing cocaine and its isomers and derivatives, among other things, and calling them, quote, narcotic drugs, end quote, without limitation. And that's a very important crimmigration quote to remember, the one that I stated just a couple seconds ago, and it's really important everywhere except maybe the 11th Circuit, given its weird Shamu decision. For deep 8th Circuit nerds, the court distinguished its 2025 decision in United States v. Buckley. Next, the Eighth Circuit rejected the Department of Justice's argument that the type of isomer possessed is an element of the offense rather than simply a means of committing the offense. Isomers, the court explains, are simply different ways to chemically define cocaine in Arkansas, meaning their means, meaning that the modified categorical approach does not apply to the cocaine isomer analysis. Even if the statute is divisible vis-a-vis, say, methamphetamine in cocaine, that doesn't give a tribunal the legal authority to dig deeper into chemical compositions. Remember that too. Final argument then. Really rejecting DOJ's argued implications from a prior Eighth Circuit decision that I need not get into. And so it all means that Mr. Ferguson will remain in prison for far fewer months. Congratulations to unnamed attorneys because the Eighth Circuit doesn't list them in their day ofs, but there's a decent chance it's the Eastern District of Arkansas's Public Defender's Office. If I'm wrong about that, shoot me an email. By the way, I misspoke. The Eighth Circuit does indeed mention the realistic probability test in a footnote, rejecting DOJ's argument that it should apply. Quote, the government argues that we should apply a reasonable probability test to assess the scope of the Arkansas statute, but that test applies only where a statute is ambiguous, and the Arkansas statute unambiguously criminalizes all cocaine isomers, end quote. Restated, the text will win the categorical approach even in the isomer context. Take that to the BIA and smoke it. All right, poor choice of phrases that I, of course, do not mean literally. But also, I'm told, not realistically possible to do so with simple cocaine or its isomers. And that is United States v. Ferguson. Sticking with the 8th Circuit, we have Fofana v. Noem et al., published by the 8th Circuit on Friday, January 9th, 2026. The 8th Circuit giveth and it taketh away. This is a very bad decision about jurisdiction. It was a bad decision for non-citizens, actually, when the case appeared on the podcast episode 64. At that time, the 8th Circuit held that collateral estoppel doesn't prevent USCIS from denying the adjustment of status application of an individual like Mr. Fofana, who an immigration court had previously granted asylum to. See, Mr. Fofana got asylum in the first place in part because of his involvement with the United Liberation Movement of Liberia for Democracy. No one in immigration court brought up the terrorism issue at the time in 2001, but by the time USCIS adjudicated his adjustment of status application, almost 2 decades after it was filed, USCIS asserted the material support of terrorism bar. The 8th Circuit said on episode 64 that that very unfair thing is okay. This is all originating in district court, and it's now returning to the 8th Circuit after Mr. Fofana won again on remand that USCIS violated the APA. This time, the district court held that the material support of terrorism inadmissibility finding was arbitrary and capricious. DHS appealed again to the 8th Circuit, and boy would I love to discuss the meat of all this. But I can't, because the 8th Circuit held that after Patel, the district court lacked jurisdiction to review USCIS's denial of the adjustment of status application in the first place. And well, that's simply devastating. The Supreme Court's Patel decision is, of course, based on an analysis by Section 242A2B. Clause II of that section states that federal courts can't review, quote, any other decision or action of the Attorney General or the Secretary of Homeland Security, the authority for which is specified under this subchapter to be in the discretion of the Attorney General or the Secretary of Homeland Security, other than the granting of relief under Section 1158A of this title, end quote. That latter thing being asylum. Adjustment of status for asylees like Mr. Fofana is governed by INA Section 209, which is 8 U.S.C. Section 1159, and subsection B of that statute makes clear that asylee adjustment, like all adjustment, is discretionary. Now, the common argument, especially before Patel, was that the decision to grant or deny as a matter of discretion can't be reviewed, fine, but preliminary findings, like whether someone is barred for the material support of terrorism, can be reviewed. Otherwise, the agencies could kinda simply do whatever they wanted. The problem is that the Supreme Court rejected that argument in a very similar context in Patel, namely the A2BI context right next door to the jurisdiction stripping provision at issue here, INA Section 242 A2BII. The 8th Circuit goes on to reject smart text-based attempts by Mr. Fofana to distinguish Clause II from Clause I, but the 8th Circuit was not swayed. Patel is just a very, very big problem, as we all knew at the time. But the Supreme Court majority did not care. So, rejecting some more arguments and distinguishing its 2016 Adam Walsh Act decision in Bremer v. Johnson, the 8th Circuit reversed the district court and will not permit Mr. Fofana or many like him to get their day in federal court. In the 8th Circuit, at least. And that is Fofana v. Noem et al. Wrapping up a busy week for the 8th Circuit, we have Aguilar-Hernandez v. Bondi, published by the 8th Circuit on January 6, 2026. This case is about asylum. Miss Aguilar-Hernandez and her son are from Guatemala. She began a relationship with a man named Caesar when she was 15 and he was 19 years old. After their son was born, things deteriorated. Caesar raped Miss Aguilar-Hernandez weekly, beat her almost every day, causing scars, threatened to kill her regularly, and called her horrible names. Miss Aguilar-Hernandez never filed a police report in Guatemala, notes the 8th Circuit. She tried to leave Caesar 3 times, but always remained back with him until she and her son came to the U.S. and sought asylum in removal proceedings. Following this decision, all tribunals have denied her case. As always, these types of claims travel under the particular social group framework, if they travel at all, and Miss Aguilar-Hernandez asserted that she was persecuted on account of her being a member in one of the following PSGs: 1. Guatemalan women. 2. Guatemalan women viewed as property within a domestic relationship. And or 3. Guatemalan women who are unable to leave a relationship. Really pretty in line with matter of ARCG, which may have been good law when all of this was being argued, but no longer is, yet again. Now true, quote, under the one central reason nexus standard, a protected ground need not be the sole reason for persecution, but the protected ground cannot be incidental or tangential to the persecutor's motivation, end quote. And here, actually, the BIA assumed at least one particular social group valid. It just didn't see a nexus. That Miss Aguilar-Hernandez's membership therein was one central reason for the terrible things that happened to her. The Eighth Circuit agreed. Specifically, it agreed that the record didn't show that Miss Aguilar-Hernandez being a woman was one central reason, although query whether Caesar or his ilk do such things to men. But here the record also showed that he was a drunk and didn't work, which the IJ believed a central factor, as was Caesar's accusations of Miss Aguilar-Hernandez's infidelity and his desire for her to support him financially. Even if the infidelity accusations are untrue, that is not because she's a woman to the courts. It's because Caesar sucks, to put it lightly. Wild stuff, asylum law. This also tanks a humanitarian asylum claim, explains the Eighth Circuit, because that distinct form of asylum still requires a past persecution on account of a protected ground finding, and the nexus is missing here. Convention Against Torture Protection denied too, insufficient government acquiescence, essentially because Ms. Aguilar-Hernandez didn't report the events to the police in Guatemala. Also, that Guatemala is corrupt generally is not specific enough to Ms. Aguilar-Hernandez, explains the court. Plus, the evidence shows that actually there's a 24-hour domestic violence court in Guatemala City with steep incarceration sentences permitted by law. Who knew? Quote, while there was evidence of serious problems with violence against women, the record established that the Guatemalan government has taken steps to combat such violence and did not acquiesce in torture, end quote. Meaning, I suppose, Ms. Aguilar-Hernandez and her minor son returned to Guatemala. And that is Aguilar-Hernandez v. Bondi. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com, that's eb-5support.com, or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Welcome back, where we have Gutierrez-Mikan et al. Of the U.S. Attorney General, published by the 11th Circuit on January 5th, 2026. This case is about Convention Against Torture Protection and ineffective assistance of counsel. Ms. Gutierrez-Mikan and her son are asylum seekers from Colombia. She testified in oral proceedings that she and her family had been persecuted by the FARC for about 20 years. She explained that after her family refused to pay extortion money to the FARC, the guerrillas raped her, burned the family's vehicle, and killed two of her uncles who tried to investigate and oppose FARC. Despite the family's efforts to escape the FARC by moving around Colombia, the guerrillas continued to discover their location and threaten them with phone calls and notes. They reported the murders and threats to the police, but the Colombian police simply put their reports into a database with other victims, explains the 11th Circuit. More stuff happened, nothing changed, and Ms. Gutierrez-Mikan fled to the United States with her son. An immigration judge didn't think that she had been harmed for the right reasons to deserve asylum in America and denied cat protection based on a belief that the Colombian government was doing enough. The BIA affirmed the asylum denial. The BIA also rejected an ineffective assistance of counsel-based claim brought against immigration court counsel. But it remanded for further CAT analysis, which the immigration judge then beefed up on remand to again deny without holding a new hearing, and the BIA then affirmed that too. The 11th Circuit affirmed the BIA. First, it addressed the ineffective assistance of counsel stuff, which it appears was presented in the form of a BIA motion to reopen. Ms. Gutierrez-Mikan alleged immigration court counsel was ineffective for failing to assert her membership in certain particular social groups, but the issue here in this 11th Circuit case is procedural. Ms. Gutierrez-Mikan didn't comply with matter of Lozada, didn't file that draconian bar complaint against former counsel, and also didn't provide counsel an opportunity to explain, etc. Procedurally, though, not always or maybe ever required in certain circuits to succeed on an ineffective assistance claim. Is the 11th Circuit one of those circuits? Well, quoting its episode 154 Ponce Flores decision, the 11th Circuit states that, quote, substantial, if not exact compliance with Lozada's requirements is necessary to pursue an ineffective assistance of counsel claim in the immigration context, end quote. Not gonna lie, I don't know what that means. Is the 11th Circuit saying that exact compliance is not required, or is it kind of being unclear and fast and loose with the words? I think the former, but what a dangerous assumption, right? Well, here the panel states, quote, because Ms. Gutierrez-Mikan does not argue and the record does not show that she substantially complied with those requirements, the BIA did not err in dismissing her claim, end quote. So I guess it's substantial compliance, everyone, not literal compliance. I don't know what that means specifically, but there you go. Also, don't quote me and don't bar complaint me. Now, Ms. Gutierrez-Mikan, without much of a legal leg to stand on because of the Lozada stuff it seems, chose not to and challenged Lozada itself head-on. Go forth and conquer. I am here for it. She argued that after Loper Bright, the 11th Circuit need not defer to matter of Lozada and can say for itself what is required of an ineffective assistance of counsel claim in the immigration context. Seems right to me. A difficult ask, though, particularly as there are lots of decisions before Loper Bright affirming matter of Lozada in the 11th Circuit. But more important to the panel, and unlike the concerns at play in Loper Bright, quote, matter of Lozada was not based on the BIA's interpretation of the immigration code. Rather, the Lozada requirements for immigration court ineffective assistance of counsel claims stem from the BIA's broad discretion in considering motions to reopen, removal orders, end quote. Interesting. So the panel's saying Loper Bright isn't at play at all, given that Chevron deference wasn't, allegedly, at play with the Lozada requirements, given that Lozada isn't actually based in the INA. Quite the holding. Something that should, to me, severely undermine the BIA's made-up Lozada requirements, right? They're untethered to the INA. But paradoxically, it's what kind of saves Lozada now. Though in a footnote, of course, the 11th Circuit alternatively explains that Loper Bright doesn't mean that it can just overturn all of its prior precedent that had been based on Chevron deference in the past. Here, precedent affirming the Lozada requirements. A holding that unfortunately appears to be firming up month after month in the circuits, although not in entirely uniform ways. With ineffective assistance of counsel dispelled, the 11th Circuit turned to CAT and affirmed denial thereof. Because by this point, explains the 11th Circuit, quote, the evidence showed that the Colombian government negotiated peace accords with the FARC, outlawed violent groups in the country, and documented FARC's violence by registering victims in a government database, end quote. As occurred in Ms. Gutierrez-Mikan's case itself. So the 11th Circuit, this dispelled the argument that the Colombian government would acquiesce to future torture. The BIA did not apply an incorrect legal standard, explains the 11th Circuit. It did not require, for example, that Ms. Gutierrez-Mikan show that the Colombian government would completely fail to protect her, despite some language it used. That language, explains the 11th Circuit, was clearly addressing the arguments that Ms. Gutierrez-Mikan was making to the BIA. It wasn't the BIA making up a legal standard and then applying it. And for these reasons, Ms. Gutierrez-Mikan lost her case. As I've been away for a minute, please allow me to continue. I shall now ponder out loud whether Ms. Gutierrez-Mikan needed to petition for review of the BIA's asylum denial notwithstanding the remand a la Riley, right? Looks like asylum wasn't challenged on petition for review here beyond the ineffective assistance of counsel motion to reopen stuff, so not really at issue, but what if Ms. Gutierrez-Mikan had? What if she had challenged asylum before the 11th Circuit? And was the BIA's remand really simply for further CAT analysis, where the BIA remanded simply for, quote, further proceedings, end quote, as reflected in the 11th Circuit's summary? Oh, the tangled web the Supreme Court has weaved in Riley. And I don't have the answers. Only questions. Frustrating, I know. I hate me too. And that is Gutierrez-Mikan et al., the U.S. Attorney General. You asked and the Third Circuit answered. It has a case. Savane v. DHS et al., published by the Third Circuit on January 7th, 2026. And just to be clear, nobody emailed me about the Third Circuit and its publications. I was just making a joke. This case about naturalization and material misrepresentation. Mr. Savane, or Savane, I'm not sure, is from Côte d'Ivoire and came to the United States as an immigrant after winning the visa lottery. Congrats, Mr. Savane. I'm going to go with Savane. Quote, the diversity visa program enacted as part of the Immigration Act of 1990 created a lottery system to allocate up to 55,000 immigrant visas to individuals from countries with low rates of immigration to the United States, end quote. Stephen Miller and Donald Trump hate it, but hey, it exists. To apply, you need to submit a petition to the Department of State. As so often seems to get diversity visa lottery recipients in trouble in these cases, that petition requires, among other things, information about all of their children. So too with the follow-up DS-230 application for a visa with the Department of State that you can submit if you're selected to get that immigrant visa. Mr. Savane applied for the diversity visa lottery and, you guessed it, didn't list that he had 2 children. Once selected, he expressly put NA in the section for children in the DS-230, that is, not applicable. He would later testify that he didn't disclose his children on the advice of a coach who essentially filled out the forms for Mr. Savane and told him that disclosing his children and bringing them to the U.S., I guess, would hurt him financially. The consulate officer didn't ask about children, and Mr. Savane came to the United States as a lawful permanent resident in 2012. He applied to naturalize in 2020. This time he listed all his children, admitted that he had not been truthful before, but did not admit that it was in order to gain entry or admission into the United States. After all, Mr. Savane believes, why would it have affected his admission? USCIS denied the naturalization application, finding he hadn't been lawfully admitted for permanent residence, as USCIS's interpretation of the statute requires, because he lied to get here. When USCIS held fast to that conclusion on 336 appeal, Mr. Savane sued in federal court, as is his statutory right. He lost on summary judgment, and he appealed, as is his right. And he did not succeed. Accepting without discussing USCIS's regulation requiring that a naturalization applicant show that they lawfully obtained LPR status before they can naturalize, the Third Circuit went on to analyze what happened here. Well, not entirely. Apparently, the Third Circuit agreed in 2016 and 2010 that, quote, a grant of permanent resident status does not meet the standard of lawful admission if the applicant was not legally entitled to it for any reason, end quote. That's Kulzanik v. DHS and Gallimore v. Attorney General of the United States, although I wonder whether Chevron deference had anything to do with those decisions. But I digress on this point. A double constant pet peeve of mine. That is, the USCIS regulation and the Chevron deference Loper Bright thing. Digressing, I know. So moving on. With that as the standard, the Third Circuit explains that 8 C.F.R. section 103.2a2 states that, quote, by signing the benefit request, the applicant or petitioner certifies under penalty of perjury that the benefit request and all evidence submitted with it, either at the time of filing or thereafter, is true and correct, end quote. Here, the Third Circuit believes the relevant application that Mr. Savane cited is the DS-230. And to the court, quote, compliance with this substantive legal requirement is a prerequisite to lawful admission as a permanent resident, end quote. Restated, Mr. Savane had to submit truthful information in his DS-230 to obtain his immigrant visa, per the regulation. He did not do so. As such, he violated 8 C.F.R. section 103.2a2, reasoned the district court and the Third Circuit. But it still has to be material. It is, explains the court. Apparently aligning with a Fourth Circuit decision from 2013, the Third Circuit held that, quote, the omission of information from an application is material, contrary to the provisions of 8 C.F.R. Section 103.282, when the omission prevents investigation into a relevant aspect of an applicant's eligibility, regardless of whether the omitted information would have led to the denial of the application, end quote. And yikes. As such, the court rejected Mr. Savane's argument that a misrepresentation is only material and therefore can only prevent naturalization if its disclosure would have made the applicant ineligible for the immigrant visa way back when. Rather, relying on its prior precedent and the Supreme Court's decision in Cungas, the Third Circuit explains that a misrepresentation can be material if it, quote, tends to shut off a line of inquiry which is relevant to the non-citizen's eligibility and which might well have resulted in a proper determination that he be excluded, end quote. A pile of mush, that standard, not gonna lie. Still, though, how can the failure to disclose children equate to a might have resulted in inadmissibility finding, as even that standard appears to require? Well, explained the district court and seemingly the Third Circuit, had Mr. Savane disclosed the children in the DS-230, Department of State rules would have required denial because he didn't disclose them in the initial diversity visa lottery petition. But a rule that would have resulted in denial at the consulate, meaning that disclosure might well have resulted in denial of the immigrant visa. So that's probably why Oil and the district court focused on the failure to disclose the children in the DS-230, rather than in the diversity visa lottery petition per se. Oil's not dumb, guys. Oil's not dumb. In a footnote, the Third Circuit kind of punted, though, on Mr. Savane's argument that the district court should not have been relying so heavily on agency regulations and the FAM to make these findings. And ultimately, actually, the Third Circuit affirmed denial of naturalization for a slightly different reason, after saying all those things. It believed that failure to disclose the children shut off a line of inquiry that might have resulted in a finding that Mr. Savane was likely to become a public charge if admitted, a different ground of inadmissibility, even though the children, by definition, weren't immigrating with him. Quote, of course, it is impossible to know 13 years later whether the omitted information would have resulted in a proper decision that Mr. Savane was inadmissible. But it would be a perverse rule indeed if we were to make Mr. Savane the beneficiary of that indeterminacy, end quote. If nothing else, explains the court, the consular officer could have then inquired whether Mr. Savane intended to send money back to his children, which it believes relevant to the public charge inquiry. And after all, explains the court, isn't that what this weird dude, the coach who helped fill out the application, advised Mr. Savane in the first place, warned him that it might have financial implications that would prevent him from coming to America? Reasoned the court. The Third Circuit concludes by reminding that, quote, there is a clear congressional mandate that only applicants who demonstrate strict compliance with all of the statutory requirements for citizenship be naturalized, end quote. And it affirmed the district court denial and, by the way, might put Mr. Savane on a path to removal. Apply to naturalize with caution, folks. Judge Freeman concurred to state that she would, quote, not rely on 8 C.F.R. Section 103.282 to resolve this appeal, end quote, because it seems she believes it ultra-vires the statute by not requiring a sufficient mens rea. Also seems that the majority's 103.282 discussion might be dicta in this regard. Read Judge Freeman's concurrence if you have a similar issue with her on the panel. And that is Savane v. DHS et al. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. You thought I was going to end without this, right? Thought I was going to miss it? Matter of EMFS by the BIA? I'm not going to miss it. And I'm going to go deep into it. We're going to end with the BIA. This case is about past persecution. And it is not a previously non-precedential decision. This is from the BIA. It makes it quite the dense read, 10 pages single-spaced, and with quite the header. Quote, death threats alone rarely rise to the level of persecution and only do so if they are objectively credible and issued by a person or persons with the immediate ability to carry them out. End quote. Meh. Check the podcast page to see what the circuits have said. The circuits govern now, right? Podcast page will have all cases in immigration published over the last 5.5 years. Do a control find for death threats. I always list it. Based on my off-the-cuff recollection, this is not an accurate representation of the law in many circuits, or at least it's more nuanced in other circuits. Also, check out Ira's book for death threats. Now let's begin. This is a family of asylum seekers from Peru. The lead respondent is a woman. She was a news broadcaster and television host for a well-known Peruvian television station, and her husband partner was the producer. Quote, after former Peruvian President Pedro Castillo gave an interview that turned hostile with another reporter at the news station where the lead respondent and the male respondent both worked, the respondents suffered threats and harassment by the former president's supporters. The respondent was physically pushed and insulted on numerous occasions as she left the news station. End quote. The couple also received 2 anonymous death threats on their doorstep, 1 week apart, one of which had 3 bullets with it. How many of you would have stuck around for that? This couple resigned their positions with the TV station and fled Peru 6 months later. An immigration judge denied asylum, and the BIA has now affirmed. I must admit, I've come away with the feeling over the last few months that I'm kind of a wuss. I am not as tough as these BIA members. I see that now and concede it. If the death threats are past persecution, Miss EMFS and her family are provided a presumptively well-founded fear of future persecution per statute that DHS must rebut, or the family gets asylum. Which is why a finding of past persecution can be so important. But they weren't, explains the BIA. I'll give it to the BIA. They address Fourth Circuit precedent head-on, likely the most favorable precedent, and hold that even the Fourth Circuit does not categorically hold that all death threats always are persecution. To the BIA, even in the Fourth Circuit, something more than a death threat is required. quote, aggravating circumstances, end quote, for example, explains the BIA, quoting the Second Circuit about what the Fourth Circuit apparently requires. Now, this case doesn't arise in the Fourth, but the BIA states clearly that despite case law from that circuit and nearly all circuits stating that death threats alone can constitute past persecution, quote, immigration judges interpreting Fourth Circuit law should not apply it in that categorical manner, end quote. Now, in the 11th Circuit, where this case arises, the BIA states that the rule requires, quote, a credible death threat by a person who has the immediate ability to act on it, regardless of whether the threat is successfully carried out, end quote. Quoting Diallo v. U.S. Attorney General. BIA thinks that that's the rule in the 9th Circuit, too, although I promise you it's a bit more nuanced. The BIA spends some time going through what it believes the law in other circuits, too. But credible or concrete threats generally cut it, at least in some circuits. Even the BIA acknowledges this in a footnote. To the BIA, the better focus should be on the, quote, cumulative effect, end quote, of the threats and other persecutory incidents. But then stating its rule, the BIA holds that, quote, a death threat that is vague, anonymous, or used merely to intimidate by itself does not rise to the level of severity required to establish persecution, end quote. Then, stating in completely unnecessary dicta that death threats alone rarely qualify as past persecution, the BIA then immediately actually states with specificity that death threats are past persecution where, quote, they are objectively credible and issued by a person or persons with the immediate ability to carry them out, end quote. So that's your legal rule, not the decision's somewhat inflammatory header. The focus is on the, quote, objective treatment by the alleged persecutor, end quote, rather than the suffering of the respondent. But I mean, I'd think that the respondent's reaction would say something as to whether the threat was credible and could be immediately carried out, no? Why so obtuse all the time, guys? The BIA also acknowledges in a footnote that, quote, several circuit courts have stated that a death threat may constitute persecution if it is so menacing as to cause actual suffering or harm, end quote. String citing the circuits. So that is literally the rule in all of those circuits, and the BIA's decision here is not the rule, see Loper Bright. Circling back to this case and the BIA's rule, it didn't believe that the death threats here were immediate enough. Plus, they were anonymous. And the respondents didn't submit enough evidence, hard evidence, about the context of the terrifying threats. Asylum seekers, take note. Bring your evidence with you as you flee. It'll come in handy later. Might I suggest taking photos as you're being threatened, beaten, what have you. Also, always have a recording device on your person and make sure it's on. And don't forget to make sure that you pay Apple to ensure that you have enough storage space for said recordings to be kept on the cloud. Quote, the respondents have also not shown that the pushing and insults by unknown individuals outside the news station where they worked rendered the threats credible or that their cumulative harm rises to the level of persecution, end quote. I've spoken enough. The BIA doesn't believe it passed persecution, and without that doesn't believe the respondents had established a future persecution claim either. This despite what's happening to some other journalists in Peru. Convention Against Torture Protection denied too, and that was it. But it's not it for me. I watched The Sound of Music for the first time. Great film, truly, and I usually get kind of annoyed by the really old films. Having watched it, I gotta think it's one of the primary films that helped shape public opinion in a manner that eventually resulted in the United States signing on to the Refugee Protocol of 1967 and eventually implementing asylum into domestic law, right? It had to be. Not to give it away, but we all assume that the Von Trapps make it over the mountain and into Switzerland, and that is a good thing and that Switzerland lets them stay, right? We all assume that? Well, my tainted immigration mind couldn't help but come to the conclusion that the Von Trapps very well might not qualify for asylum in America today as interpreted by the BIA and Attorney General. Certainly not Maria and the kids on their own with a family-based claim. Not without something more, I'd think. But even the captain. No past persecution. We've learned that through this decision alone. In 1938 Austria, before the real Nazi horrors began, before the war, nothing bad had happened to the captain at all, actually, so no past persecution claim. And Austria by then is part of the Nazi government, I guess, whatever you would call it before the war. So you run into recent decisions like matter of NNB and other cases, not as directly on point, that certainly provide support to reject claims based on forced military conscription. And then what if in an alternative universe he accepts under duress, captains that ship for a month or two, and then flees? Persecutor bar, right? With no duress exception a la matter of Negus. Don't get me wrong. The captain of the family could get asylum from a favorable USCIS officer or immigration judge, but that adjudicator or IJ better have a grant rate that DHS and DOJ approve of, or they risk their job. And in any event, I'd say an asylum grant far from secure. Ironic to me, at least, given that protecting people like those who fled pre-World War II Nazi-controlled areas is kind of the whole point of the asylum framework that followed World War II. Or, I don't know, maybe I've simply knocked down a house of cards and the BIA listeners, and I know there's some of you, believe the Von Trapps would qualify. If so, drop me a footnote sometime. How do you solve a problem like Maria? Deep cut, I know. Another contender was simply, so long, farewell, auf Wiedersehen, goodbye. And that is matter of EMFS. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.